may be seated. Thank you. Well, welcome to today's session of the Kansas Court of Appeals at Johnson County Community College. We are really thrilled to be here today. Our court has 14 judges, and we generally, every month, we have dockets every month and try to travel around the state as much as we can. We have a panel at Washburn Law School today. We have a panel in Wichita at the Wichita Federal Courthouse. We have had dockets in as far as Colby and Pittsburgh, you name it. We try to travel around to give students and members of the public an opportunity to see the court in action and to ask questions. So we are very happy to be here today. I am particularly happy to be here today because I went to this wonderful college out of high school at Shawnee Mission North High School, and then came here before I went on to KU. My husband is also here today, and he was also a Johnson County Community College associate's degree graduate, played on the baseball team here. So we have a lot of connections to this school. With me today, to my right, is the senior judge on our panel, Judge Joseph Perrin. Judge Perrin was a district judge in Johnson County for many years before he got on the Court of Appeals, and he is the longest-serving judge on our court and among the longest-serving judges in the state of Kansas. To my left is Judge Tom Malone. Judge Malone, before he came on our court, was a district judge in Sedgwick County, so he has many years of judicial experience as well. With that, we are going to call the docket today, or start the cases today. We have 3 cases set for this morning. I think you got a little summary of them in the school. Students got a little summary of them, and I think you may have even gotten the briefs. Yes, Gwenda is saying yes, you got the briefs. So, Counsel, you've got not only a hot court, you've got a hot room here today. They know everything about your case. So I think it's a great learning opportunity to see how a case ends up getting argued before our court and discussions of what happened in the trial level. After the cases are concluded, we will be happy to answer any questions any of you have. The only downside is we cannot answer any questions about the exact cases you've heard, not hypothetically, not otherwise. We cannot discuss those cases, but we can discuss anything else about the procedure of our court or anything you want to know. All right, for the attorneys that are appearing today, I ask that if you are the appellant, you let me know how much time you want to reserve for rebuttal. For those present in the audience, each side gets 15 minutes to argue, and the appellant can reserve time for rebuttal if they wish, although the appellee cannot. So they'll be letting me know at the beginning how much time, if any, they want to reserve for rebuttal. I have my cell phone here on which I will be keeping time because I recalled right, there's not a clock in here that I can see. So if you see me looking down at my phone, I'm not texting or doing other business. I'm trying to keep track of the time. The judges will be asking questions throughout the oral argument. I'd also ask, we generally ask that the parties not waste their 15 minutes really going over the facts of the case because we're very familiar with the facts. But in this case, if the appellant wants to take a couple minutes to go over the facts, that's fine, and I won't count that against your time, but no more than a minute or two, okay? So with that, we'll call the first case of the day. If the parties would step forward on State of Kansas versus Scotty Lindsay and announce who's here today.
Good morning, Your Honors. Corinne Gunning appearing on behalf of Scotty Lindsay, the appellant.
Okay.
On behalf of the state of Kansas, Ethan Ziff-Sigler from the Wyandotte County District Attorney's Office.
Okay, Ethan Ziegler.
Ziff-Sigler, ZIPF-SIGLER.
And are you on the brief?
I am not on the brief.
Okay, so I need your bar number.
It's 24220.
And the first name was?
Ethan.
Ethan, right, okay. All right, and did you wish to reserve any time for rebuttal?
Yes, I would like to reserve 3 minutes, please.
Okay, is that, can you all hear her back there, or is her microphone on, or?
It appears to be on.
Need to get it just closer.
Move closer to me. Is that better? That sounds better.
You're probably gonna have to lean into it a little bit, I'm sorry.
It's okay. This is my first experience with a microphone like this, so.
Okay, thank you, I think that's better. I can hear
Okay.
her better, I don't know about everybody else. Okay. So you said how long, 3 minutes?
3 minutes,
Okay,
please.
you've got it.
All right, I did raise several issues in the brief, and I'm prepared to discuss each of them based on the interests of the court. I will start with issues 1 and 2 on the limitation of cross-examination, and then, if time permits, move to 3 and 4 regarding the motion for new trial. And I will simply let issue 5, the cumulative error issue, stand on the brief. I will give a brief factual background. Lamont Boyd was shot in this case, and he identified Michael Wright and someone he knew as Scott K.C. as the shooters. And at the same location, Melinda Bates Fuller was also shot and killed at the same time. Michael Wright was ultimately picked up by the police while he was breaking into cars and identified someone he knew as A1 as the shooter and indicated that someone named Brandy Strobel was also present in the shooting. Police ultimately went to Brandy Strobel's house where they located my client, Scotty Lindsay, and arrested him. They also searched the house for evidence related to the shooting and did locate a gun at the house. Ultimately, Scotty was charged with premeditated first-degree murder of Melinda and attempted premeditated first-degree murder of Lamont, as well as criminal possession of a firearm by a convicted felon. Ultimately, a jury convicted Scotty of second-degree murder of Melinda and attempted second-degree murder of Lamont, as well as the criminal possession of a firearm by a convicted felon. And the district court sentenced him to 688 months in prison. For the reasons I have stated in my brief and to be argued today, I would request this court reverse Mr. Lindsay's convictions and remand for a new trial, or in the alternative, remand for a new motion for new trial hearing with conflict-free counsel. I have joined issues 1 and 2 because they both relate to the limited cross-examination of Amber Pavlich. First, I argue that this limitation by the district court violated Mr. Lindsay's right to present a defense. And then second, that the court's sua sponte limitation of cross-examination constituted a judicial misconduct.
Counsel,
Go ahead, no, you go ahead.
Counsel, what admissible evidence could she have provided the finders of fact? It seems like she was being asked for her opinion on guilt or innocence, which is generally something we do not allow someone to testify to.
As I argued in the brief, and from my perspective, what she had testified to is what she had already communicated to Scotty, is that she had this belief that he did not have a gun and that the charges were, in her words, bullshit, and that she did not believe that he had shot those two people. What was limited, I'm sorry, Judge.
Yeah, I'm sorry to interrupt you, but why should we care what her opinion was as to guilt or innocence? I mean, you can present evidence on facts that occurred, but asking someone or allowing someone to testify as to whether they think this person is guilty or not is not something that we would generally allow a witness to testify to.
Correct, yes. And she had already testified as to her opinion. What had happened is that the state, during their direct examination, discussed about her relationship with Scotty and her knowledge of him as a person and his character and things like that. And so what defense counsel argued was that they were getting to the point where they were asking her why she believed he did not have a gun, why she believed he was not present at the shooting. What was it about her relationship with Scotty, her knowledge of him as a person, or what other evidence she had to support her belief that he was not present or that he did not have the gun. And so it was the facts supporting her opinion that was limited. Her opinion got in, the facts supporting it did not.
Well, the opinion got in, and then the judge immediately shut it down. And he has a responsibility under case law to control the proceedings of the trial, and we have cases that say when that sort of evidence comes in, he has a responsibility as the judge, sua sponte, to take action to prevent that kind of evidence from coming in. Isn't that correct?
I understand there is case law. I believe there is conflicting case law, which I have cited in my brief, that a judge it is actually the state's responsibility to object if they find that evidence objectionable. And in this case, the state did not object and explained that their reasons for not objecting is that they wanted that evidence in because
they thought that would open the door for allow them to bring in evidence of his prior
Correct.
homicide charge.
And so in this case, my opinion, and I guess my opinion doesn't matter, but what I briefed is that the judge took the state's position and advocated on the state's behalf to leave that evidence out, even after the defense counsel did explain that he wanted to get in actual evidence and actual facts to support her beliefs. The judge still
And he
decided
didn't
not to.
proffer that to the court. He didn't present a proffer of what evidence he was trying to get in, correct?
Not specific facts, but simply the
And
the
if
general.
her evidence was, from reading the transcript, it looks like she may have been ready to say that she was with him kind of almost an alibi sort of witness, that she was with him and he couldn't have been at the location at the time or whatever. Defense counsel could have asked all of those questions about where she was at the time of the incident and if she knew where he was. It was the point of saying, I don't believe he's guilty, and this is why I don't believe he's guilty, that crossed the line. Don't you think? Why isn't that where the line was crossed?
And I mean, that is what was asked and answered. And again, you're correct, there is no proffer in the record of what exactly he was going to ask and what exactly she was going to say in response to those. He simply indicated that he was going to continue forward and get unobjectionable evidence in, and the court simply cut him off and said, we're not going anywhere near that anymore. And so I do believe that there are limitations on the court introducing themselves as what I would characterize as an advocate in this case. Yes, they do have an obligation to enforce the rules of evidence, but case law is also very clear that it is the party's obligation to object and the court's obligation to rule on those. And typically, the Supreme Court has found that it's not proper for the court to introduce themselves in the manner that the court did in this case. Because if there are no further questions on those first two issues, I think that I would just say that the limitation of the cross-examination did limit Scotty's right to present a defense because his defense was complete innocence, and it was the defense counsel's argument that her testimony did go to that defense. And so I believe that it deprived the jury of the ability to review all the evidence in the case to make a finding on Scotty's guilt. And I also believe that everything sought from Amber in this case did have direct bearing on that. And so if this court does find judicial misconduct, that is not harmless because it does go directly to his defense and claim of actual innocence, and so it would actually have bearing on the case. Without further questions, I will move on to issue 3 and 4, which I again combined because they both relate to the motion for new trial. First, his claim that his defense counsel was ineffective, and then the court's failure to appoint conflict-free counsel upon the clear delineation, showing that his counsel was conflicted because of the allegation of ineffective assistance of counsel. Specifically, the alleged defense counsel error was the failure to object to Brandy Strobel's recorded statement. She testified in this case and made several statements indicating that she did not see Scotty with a gun. She had no recollection of IDing Mr. Wright. She did not hear gunshots at the time. Again, she was present at the shooting, according to Mr. Wright, and that her recorded statement contradicted all of those things. She testified differently from her recorded statement and was released by the state as a witness and was not planned to be recalled.
I have a couple questions. One, the defense had the recorded statement ahead of time. The recorded statement was no surprise or anything to the defense.
Correct.
The defense knew about the recorded statement. And during Ms. Strobel's direct examination by the prosecutor, she was confronted 4 or 5 times with the transcript of the recorded statement saying, look at that and see if that doesn't refresh your memory. Because in her, and I'm saying this for the benefit of the group here, because in her recorded statement, she said that she saw Mr. Lindsay with the gun. After the first gunshot, she saw Mikey run out. And then Mikey was running outside when she heard the third gunshot, or the second gunshot, which would clearly place Mr. Lindsay as the shooter of the individual up in the bedroom, the one that was killed. In her trial testimony then, she indicated that she never saw a gun, she never heard any gunshots, and so she was confronted several times with that. So she was confronted with that. The defense attorney had the right to cross-examine her about the inconsistencies in the statements that the prosecutor was trying to elicit. And then during the defense attorney's cross-examination, he did ask her about evidence that was only obtained from that interview. He said, did Mikey have the hood pulled up over his head, and did he jump into the back seat? And she said yes. And the only place that information had ever appeared at that point was in the recorded interview. So wasn't that an adequate opportunity to cross-examine about everything in that recorded interview? Why was that not sufficient? Why was it then error to introduce the audio recording when they'd already been discussing it with her and he'd had a chance to talk to her about those things?
Well, I guess my response would be that the recorded statement still remains hearsay. And the introduction of hearsay is not allowed. And the transcript of, to my recollection, and you or opposing counsel can contradict me if I'm incorrect. To my recollection, the transcript of the recorded statement did not come in as evidence. It was the recorded statement itself that came in as evidence for the jury to have. And they did not read the transcript verbatim. They picked and chose certain things. And so I think that the piece of evidence itself, and she obviously said more than just the things that they picked and chose. And so I think that the opportunity to cross-examine on the entire piece of evidence, the entire interview, is important. And I also just would say the state released her knowing that they wanted to get that piece of evidence in. And so they got that piece of evidence in without any opportunity to actually cross-examine the witness about the full piece of evidence. And so defense counsel did have the opportunity to cross-examine about the pieces and parts, but not to cross-examine about the whole. And so...
Well, counsel would have been able to do that, wouldn't he? Wouldn't couldn't he call her as a witness?
He could, but it's not his obligation to do so. And so, I mean, and I guess if he hadn't, obviously, if you think that he should have called her.
No, I'm not saying whether he should or should not. It's just that didn't he have the opportunity, if he so chose, to recall her and testify on behalf of his client?
He did, but the defense has no obligation to present any witnesses. And so the state got a piece of evidence in that was hearsay without the opportunity to cross-examine on that piece of evidence, and then you would shift the burden to the defense counsel to sort of call a witness on their behalf to rebut that.
You're
Thank
heading
you.
into your rebuttal time.
And so I guess I would just say that his counsel was ineffective by failing to object to that statement. And the court was also incorrect in failing to appoint conflict-free counsel upon his admission that he had failed to object to inadmissible hearsay.
Thank you. We'll await anything else in rebuttal. Ready?
May it please the court, I'm Ethan Ziff-Sigler on behalf of the Wyandotte County District Attorney's Office for the appellee. I am going to maybe over-explain a few things. I know your honors know most of this, but just because we have an audience, I might
That's fine.
be a little over-explanatory. Let's imagine a world in which a prosecutor and a defense counsel hate each other. They are petty, they dislike each other immensely, but they personally and independently have decided that the best way to handle this is to be extremely petty at trial. They ask questions they know are illegal, they elicit information they know is inadmissible, but neither objects because they know they're getting petty, foolish answers out of witnesses and they're attacking each other. Is the judge required, because neither of them object, to let his trial become a circus? And the answer is, I believe, no. Judges are tasked with controlling the courtroom, and that includes controlling the information that comes in, sometimes without an objection. And that is because a judge is not there as a passive observer, they are there as an arbiter of what is supposed to be admitted. They do not have to let their trial become a circus. They do not have to let clearly illegal evidence in just because it hasn't been objected to. They can control the courtroom, and the case law is clear that a judge has not only the ability but the duty to maintain a controlled courtroom. In this case, the real threshold question is, did Judge Grosco err in not allowing inadmissible and illegal evidence in? And the answer is simply no. If the state, if we take it on the other way, the state had a detective on the stand and they said, "Detective, do you believe the defendant is guilty?" The judge does not have to wait for the defense attorney to stand up. The judge can say, "I know the answer to this question and we'll draw a mistrial. In the interest of judicial economy, I'm going to cut that detective off before he can even answer it." And if I'm the prosecutor, I might even get a call from the disciplinary administrator because we know that that question is not admissible. You're not allowed to ask a witness, "Do you think the defendant is guilty?" When we're breaking down whether or not this case is reversible, the threshold question is it structural error? If it's structural error, that basically means it's a constitutional error of such magnitude that we don't even ask if the error was harmless, it just automatically reverses. And in this case, it's clear from the case law this is not structural error. In Kansas, judges are allowed to ask questions. They are, in certain circumstances, even allowed to exclude evidence sua sponte, or on their own. Because judges are allowed to do that, the Court of Appeals then has to weigh, one, whether it was error what they did, and two, what was the effect of the error. And that means it's non-structural, which means the second question we get into is harmlessness. And really, this is where, even if the state concedes that Judge Grosco is wrong in his objection, the defense has not at any point articulated what harm was done from this objection. They haven't articulated what line of questioning was cut off. The single question that was cut off was, "Do you think the defendant is guilty?" That is not a relevant question. That is not an admissible question. So any other evidence that may have occurred from a further cross-examination has to be preserved in one of two ways. It has to be proffered to the court, or it has to be proffered even in a brief of, Mr. Sexton didn't say this, but there is a good faith basis to believe that there was additional evidence. And in this case, there simply wasn't. This has to deal with the cross-examination of a witness named Amber Pavlich. She was not an eyewitness at the scene, and she was not an alibi witness. So there's really no indication that there was any other questioning that could have occurred after Judge Grosco stopped that question that would have been beneficial to the defense attorney. So at this point, even if we were to concede that Judge Grosco telling Mike Sexton not to ask any further questions stopped him from going on. This court doesn't have the ability to weigh that versus the evidence that did come out and then determine that there was some harm in it. So the error is ultimately going to be harmless. But I don't think that Judge Grosco made a mistake. This is not an admissible question. You are not allowed to ask a witness their opinions on the ultimate determination of guilt or innocence. That's the sole province of the jury. So the first question, did it prevent a defense? No. There was simply no argument that there was more of a defense to be presented. And then the second question, did the judge fail to be an impartial jurist in this case? No. Again, this is an inadmissible question that the judge did not allow in, and there's no indication from the record that the judge belabored it, that the judge openly harangued or put the defense attorney on the spot in front of the jury to try to humiliate him. It was simply this is not allowed. Do you have anything else you want to ask? You're not allowed to ask this line of questioning. And because the judge did not make a big show of it, the judge did not try to humiliate the defense, the judge did not make any opinion as to guilt or innocence, the judge never became a partial or one-sided judge, and the defense was never denied due process of an impartial jurist. So that would be the state's arguments to 1 and 2. On the ineffective assistance of counsel, I'm going to slightly reverse the order and start with point 4, which is, was conflict counsel necessary? Generally, if in a motion for a new trial, ineffective assistance of counsel is argued, the court is supposed to appoint a second counsel, or what we call conflict counsel. That's because we just typically don't want defense attorneys having to argue their own ineffectiveness, because if you ask me if I'm a good attorney, generally I'm going to say, yes, I'm a very good attorney. So we ask that conflict counsel be appointed. In this case, though, it was just simply unnecessary. The sole issue of ineffective assistance of counsel was Mike Sexton ineffective for failing to keep out a recorded statement? That is a question that is solely a question of law, and in that case, there's really no reason for conflict counsel. The judge is in just as good a position as conflict counsel, me or your honors are now, to determine the admissibility of the recorded statement. So conflict counsel in this case wasn't necessary because the sole threshold question can be fully determined based on the record and is not necessary that we go into any sort of factual finding that would require an independent counsel to review the record.
And in this case, didn't counsel admit during argument on the motion for new trial that he should have objected to the admission of the recorded statement, and he didn't?
That's correct. And this is raised because Mr. Sexton, who was the defense attorney in this case, filed a post-conviction motion for new trial in which he said, I should have objected this to keep it out. So he had brought this issue to light in the first place. Going back from that then, since conflict counsel isn't necessary, the real question then becomes point 3, was Mr. Sexton ineffective for failing to object to this? And again, it's helpful to almost start from the ending. When we're talking about ineffective assistance of counsel, we talk about a case called Strickland. Strickland says that when we view ineffective assistance of counsel, we first ask, was the behavior of counsel below an ordinary standard of care? And then if we determine that it was, we have to ask, did counsel's behavior below a standard of care affect the outcome of the trial? And in this case, if we skip right to the end, even if you assume Mr. Sexton was ineffective, you really can't say that it affected the outcome of the trial, because even in a perfect world where Mr. Sexton objects to the admission of that evidence, the state has more than enough tools at its disposal to cure that inadmissibility, to cure the hearsay, and to ultimately allow the recorded statement in. So it doesn't have any impact on the trial, because even if Mr. Sexton stands up and says, I object, the state then has an arsenal of tools to get in the recorded statement anyways. A recorded statement is admissible for the purposes of impeachment. It's, in this case, it's admissible because Kansas uniquely has an exception, well, is one of those states which has an exception to hearsay, where if a witness is subject to cross-examination, you can get their out-of-court statements in. So again, this, aside from the fact that I would argue at trial the foundation was laid to allow this statement in even over the objection, so it wouldn't have made a difference, even if there was some defect in that the cross-examination wasn't full enough, if Mike stands up and says, I object, the state can still cure it. So at the end of the day, when the court is wondering, should this be reversible because this should have been taken care of at trial, ultimately what the court can say is, no, it would have made no difference because even with an objection, the state would have easily been able to cure any problem with the admissibility. The statement comes in anyways. The trial proceeds exactly as it proceeded in the real world, and so there is no reason to reverse. Finally, the defense argues cumulative error, that is, that the multitude of errors during the trial deprive the defendant of a right to a fair trial. In this case, there is only one trial error alleged. That trial error is that the judge objected sua sponte, and that is going to be fully determinative of the cumulative error analysis. If you find there was no error, there can't be cumulative error. You can't accumulate a single error. I would argue that the ineffective assistance of counsel doesn't go to the cumulative nature, because cumulative error has to do with identifiable trial errors, not necessarily counsel errors. So in this case, because there was no error in Judge Grosco controlling his courtroom, because Mike Sexton, even if he objected, would not have been able to keep those statements out, there is no error that occurred in trial that has been identified here today, and the state would ask that you affirm the defendant's conviction.
Thank you very much. Any questions?
Thank you.
Okay, thank you. Give you a couple minutes.
Quite the presentation. First, I would say that in this case, there's no evidence of Mr. Ziegler's hypothetical of a circus that is happening in the courtroom. And if a police officer were asked, do you believe the defendant is guilty? I believe the court would say, don't ask that question. You can ask him reasons why he believes the defendant is guilty or not guilty, but you cannot ask the question of this. In this case, the question was, you wrote that you know he's not guilty of that, quote, bullshit, end quote. Is that what you wrote? And the court stopped that question, said, I'm not going to let that in. I don't know why the state's not objecting, but you can't get it in. And Mr. Sexton said, let me ask this, Your Honor. I was going to ask what facts she had of that. Am I allowed to do that? And the court said no. So the court cut off all questioning related to Amber's knowledge of why she believed that Mr. Lindsay was not guilty altogether. And
Counsel,
Are you saying that he can ask, he can't ask what her opinion is, but he can say, what reasons do you have to believe that Mr. Lindsay is not guilty? You think that's an acceptable question?
I wouldn't phrase it that way. If I were counsel, I believe the question would be more of, you investigated like with the police officer, you investigated this, what evidence did you find? You've known Mr. Lindsay for this long. Were you with, what were you doing? The questions that you were asking about. Can I ask about facts regarding why she believes this? But the court cut off all questioning altogether, and
because
so
the
Mr.
question was
Sexton-
why. Tell us why you believe he's not guilty. I mean, it's
Right.
assuming
Right.
that she believes he's not guilty. So you're indirect. You may not be directly asking, although in this case you may not be directly asking what's your opinion, but you were certainly indirectly asking that.
I disagree. If you're asking of facts that support something, facts are evidence and they can come in, and I believe that that's what defense counsel was asking for in this case, is facts to support Mr. Lindsay's defense, not necessarily facts to support her claim, her opinion, but rather his claim defense of actual innocence. And I believe that that's the questions that, again, I lack a proffer, and so I recognize that hurdle. But I believe that the court just cut off any concerns regarding this altogether, and I believe that that's why Mr. Sexton just simply sat down and said, well, I'm not going to get anything in, so I might as well, I guess judge has stopped me, and so any further inquiry of this witness is
You are out
fruitless.
of time. Is there any other questions? Thank you very much.
Thank you.
The court will take this matter under advisement and issue an opinion as quickly as possible. Thank you, counsel, for your arguments. The next case up is, just a moment here. Nathan Jarvis versus Kansas Department of Revenue. The parties state their appearances, please.
Please support Joanna Lobster of the Kansas Department of Revenue.
Okay.
Please support Sheena Boyd for appellee Nathan Jarvis.
Okay, and did the appellant wish to have any rebuttal time?
Yes, Your Honor, 3 minutes.
3 minutes, okay. Whenever you're ready.
Thank you. Thank you. May it please the court, I'm Joanna Labastida. I'm representing the Kansas Department of Revenue. Just as a quick overview for the audience who may not know, when someone is accused of a DUI, there is a criminal proceeding, and then there is an administrative proceeding to potentially suspend their driver's license. They do have overlapping facts, of course, but they are different standards for the criminal side versus the civil side or the administrative side. In this case, the only issue that I raised before this court is whether the district court erred by granting the request to set aside the administrative order of suspension of the appellee's driver's license, Mr. Jarvis. Two subsections to that issue, though. The first is that the district court erroneously found that the officer did not have reasonable suspicion to stop Mr. Jarvis's car in the first place. And then related to that, the district court erroneously held that the amendment to KSA 8-1020 subsection P, that the legislature had intended for constitutional issues to be decided.
Let me interrupt you for just a minute.
Yes.
The court clearly found that there was no reasonable basis to stop this vehicle.
That's right.
Okay. Do you have to have a reasonable basis to stop the vehicle in order to request a test?
I would argue that that plays into the overall.
Just a simple question. Do you have to, in order to request a breath test under the statute, it says, one or more tests may be required of a person when, at the time of the request, a law enforcement officer has probable cause to believe the person has committed a violation of the DUI law, and the person has been arrested or otherwise taken into custody for the violation of a state statute. So, does the fact that the judge clearly found that there was no basis to stop this vehicle, why doesn't that end the discussion right there? Because then if there was no basis to stop, there was no basis to request that he take a breath test.
That, with the case law, criminal case law being what it is, I would agree with that statement.
And I'm not talking about an exclusionary rule. I'm just talking about if there's no basis to stop, there's no basis to ask.
Right. Well, just with the argument being, the question what it is, our argument is that the court erroneously held that he did not have a basis to stop the vehicle. But I understand what your question is, and I would agree that the current state of case law, or even the statute as you read it, would require a basis to stop the vehicle.
And in this case, you argue that the judge was wrong in deciding that there was not a basis.
That is right.
But the judge based his decision pretty much entirely on the credibility of the officer and said, I don't believe anything he said. So, and we don't judge the credibility of witnesses on appeal. So what are we to do with that?
That is a difficult hurdle for us to overcome. I completely
Yeah,
understand.
it's very
that.
difficult.
Yes. And I was the attorney that tried this at district court as well. And I would have to agree that the officer's demeanor probably did not help his testimony. But
And that's why we don't reevaluate credibility, because that judge is there to see the officer's demeanor and to decide whether he or she is going to believe what the officer is saying. And in this case, the judge simply did not believe it.
I do take a slight issue with that overall finding by the court, because he did hold later on in his memorandum decision that once the officer stopped Mr. Jarvis and interacted with him after that, he would have found that there was reasonable grounds to request the evidentiary breath test. So I think the officer's demeanor at trial didn't help his testimony, but the facts that he was testifying to were eventually supported by his investigation later on. And unfortunately, he testified to things that happened before he started his in-car camera, and that would have supported the reasonable suspicion to stop the vehicle. And the video that occurred after he stopped, everything that happened after he started the video didn't necessarily support his testimony, but I would argue that the officer's testimony to what happened before the video should have been considered. But I think because of his general attitude on the stand, the court...
And the fact that the video didn't support what he was saying, or at least you couldn't see the same things. And I know the argument always is you can't...
Right.
The video
the angles and whatnot.
distorts the
Exactly.
vision. But, so I'm back to my question of if there were, how do we get, what is your best argument that we can even move past the no reasonable basis to stop, assuming that we can't evaluate the credibility of the witnesses, and given the fact that, assuming the fact that there was no basis to stop this car, how do we get to a valid request to take a breath test?
Because I don't believe that ends the question, whether or not it stops the vehicle. Now that we're kind of discussing it, I do think that the officer has to consider, or the court should consider the whole encounter, not just the stopping of the vehicle. And the subsection that you read includes whether or not there's a proper arrest as well. And after the officer stopped this particular appellee, the court found that there would have been proper reason to arrest him. So I think the question is more encompassing than just stopping the inquiry at whether or not he had reasonable suspicion to stop the vehicle in the first place.
Counsel, using your argument, it would seem that police officers can stop anyone they would like to, and if they find something, even if there is no reasonable suspicion, no probable cause, if they find something, then it's okay. And I don't think that's what either the statute here or the Fourth Amendment jurisprudence says. We don't want them to do those things, even though they might find something of a criminal nature or a civil nature that would allow them to withdraw the driving privileges.
And I would agree with that statement only in the criminal context. I would agree with that statement in the criminal context, but this is a civil proceeding. The implied consent statutes make room for that with the subsection that deals with the remedial nature of those statutes. Martin versus Kansas Department of Revenue is a very big case in our world, and it dealt with that exact same question, whether or not the exclusionary rule, if you should exclude evidence that the court has found to be illegally obtained, that exclusionary rule does not apply in administrative proceedings.
Let me interrupt you with some questions here.
Yes.
A line of questioning.
Oh, great.
And ultimately, the fundamental question is, why are we even talking about the exclusionary rule, or why do we need to talk about it? Mm-hmm. I'd like to focus, since Martin, you were talking about Martin,
Yes.
and since Martin, the legislature amended 8-1020 subsection P,
Yes.
right? And that's mainly what this case is about, correct?
That is correct.
Do you have the language of that amendment in front of you?
I can get it. Yes, Your Honor.
Now, the new amendment says that basically in an administrative proceeding, like a driver's license suspension case, when it gets to district court, now the court can consider and determine the lawfulness of the law enforcement encounter. That would be the basis for the stop, right?
That is correct.
That part of the statute at least abrogates Martin, correct? Because in Martin, the court said a party can raise constitutional issues, but the district court can't decide them because that wasn't one of the grounds for a court to consider back when Martin was decided, right?
That wasn't a grounds for consideration, yes.
But now the statute clearly says the court can consider and determine the lawfulness of the law enforcement encounter, i.e. the basis for the stop. Is that correct?
That is what the subsection says.
And then the subsection goes on to say that if the court finds the grounds for the action by the agency have been met, the court shall affirm the driver's license suspension, correct?
Yes.
Now, can't we at least glean from those words that if the court finds that the grounds for the agency action have not been met, the court won't affirm the driver's license suspension? Is that at least a fair reading?
That is a fair reading. However, I would argue, and it's this position of Kansas Department of Revenue and even another panel of this court, that that is not what the subsection, that the subsection didn't put that in the reading, and we're basically reading too far into it to say that the legislature intended for the court to be able to dismiss administrative suspensions based on the stop.
Well, the Judge Vano, he kept saying there must be some reason for this amendment. Why do you allow a judge to determine now if the stop was good, if the judge can't do anything based upon his findings, correct? That's kind of where our judge was coming from, right?
That is what he said in his opinion.
Why isn't the language of the last sentence, though? It tells the judge, I'll affirm the agency action if the grounds for the agency action have been met, right? It expressly says that. Can't we at least glean from that if the agency action hasn't been met, he won't affirm the administrative suspension?
I think that line actually proves our argument in that the legislature obviously intended how to put very declarative language in the subsection, and it chose not to. And so, or maybe by mistake, it didn't include that. But as Wiggum versus Kansas Department of Revenue held, the legislature didn't go far enough to change the statute.
We don't need to follow Wiggum, of course. And
No.
it's on a petition. Petition for review has been granted,
That is correct.
which kind of tells me something.
We often say they don't take petitions for review to give us an attaboy.
Right. Believe me, I worked for the appellate defender office for years. I completely understand where you're coming from.
All
with
right,
that.
but I'm being argumentative here, but if I'm right that this new amendment is clear enough, that if the court finds that the grounds for the agency action have not been met, the judge shall not affirm the suspension. If that's a fair reading of this new amendment, do we even need to talk about the exclusionary rule? Because I sort of agree with you, the exclusionary rule applies to criminal cases, not administrative actions. But do we even need to be talking about it? To me, the answer is in the language of the amendment. It tells the district judge whether it tells the district judge that you can now consider and determine the lawfulness of the law enforcement encounter, i.e., was the stop valid? And there's got to be some reason to make that determination, and that is, if you find that the stop was bad, you don't uphold the driver's license suspension. And forget the exclusionary rule. The judge is just following the language of the statute. Why am I wrong in saying all that?
I don't necessarily think that the court's statements here are incorrect, but as an advocate for Kansas Department of Revenue, I have to argue the opposite side, that the court in Wiggum was correct in that the language doesn't go far enough. And Justice Beyer, in a very famous line for at least defense counsel, said that it is not the court's role to darn the socks of the legislature. It isn't, if the court, or if the legislature incorrectly did not put language that goes far enough to change the law as it currently stands, it's not the court's responsibility necessarily to fix it for them.
I know we're way over your
Yes.
time here, but I had a question I wanted to ask too, because you have not been on the hot seat long enough. Neither you nor counsel for Mr. Jarvis mentioned the Sloop case. And I'm wondering why Sloop wouldn't be applicable here. In Sloop, the Supreme Court said an arrest must be lawful before an arresting officer is authorized to request a test. And this was a 2012 Kansas Supreme Court case. So, and in that case, they found there wasn't a basis for the stop, even though they had a valid traffic no tag light, and nobody disputed the truthfulness of that fact. But they found if there was no basis, an arrest must be lawful before an officer is authorized to request a test. So why is Sloop not applicable here?
I would agree that it probably is applicable, except if I remember correctly, the facts of Sloop were that he had a valid reason to stop the vehicle,
Right.
but then after that, there wasn't necessarily enough evidence to support
DUI, right.
DUI. Here, we kind of have the opposite problem, except that, of course, we would argue he did have reason to stop the vehicle, and then the evidence after that, even the district court agreed there was sufficient evidence for probable cause. So I think it would apply to this case, except that the facts of this case still support a proper arrest.
So you're focusing on the arrest for the DUI, not the arrest, the stop.
I think the stop, the testimony of the officer supports a lawful stop as well.
Okay, thank you. We'll still give you a couple minutes in rebuttal.
Good morning. May it please the court, Sheena Foy for appellee Nathan Jarvis. This is my first appearance in front of the Court of Appeals, so I thank you for having me. Kind of already covered a lot of the issues. I think the court's laid it out pretty clearly that the issue of reasonable suspicion was addressed pretty succinctly and forcefully by the district court in this case. And so then we're left to whether or not there can be a license suspension following an unlawful stop. And it is our position that no, there cannot be, based on the new amendment, not new, but the 2016 amendment to the statute.
Counsel, are you familiar with the Sloop case? We noted, as Judge Arnoldberger pointed out, that neither one of you cited it in your briefs.
I am familiar with it, and as soon as you mentioned it, I recognized that I should have cited it. Counsel before me is correct that our facts are a little bit different in that, I was trying to narrow in just on the reason for the stop itself versus getting into whether there was a basis for a lawful arrest. But yes, I wish that I had included that case in my briefing.
Do you think it's applicable to this case? The Sloop decision?
Yes, I do.
Well, how is it applicable when our judge said that there wasn't a good stop here, but the judge went on to find that if you get past that, there was reasonable grounds to request the breath test here, meaning the probable cause for a DUI.
Correct. So we had raised several issues at the district court level that we did not appeal those particular findings.
Correct.
And so I think in his decision, he was addressing everything that we had raised at the district court level. But just because there was then later facts that the officer observed that led for probable cause to arrest for DUI, that does not, he doesn't then get to bootstrap back to include those facts as the reason for his stop. I would disagree with counsel before me that there was testimony that would support the fact that there was facts prior to the video starting that the officer observed that would have been the basis for the stop. I think the testimony of the officer in the record was that the violations occurred on an unlaned portion of the road and the video begins on a laned portion of the road. So I would just like to